For years, stateless people in Europe often existed in a legal grey zone. They were present inside the system, but invisible to it. Authorities could see the person. Files existed. Registrations existed. But the central legal question remained unanswered. Does this person actually have an effective nationality? And if not, what happens next? Today, Europe is finally beginning to confront this problem, but a deeper question remains. Is Europe truly solving statelessness, or simply becoming better at recording it? Starting in June 2026, European asylum and migration systems will increasingly be required to identify and record indicators of statelessness during procedures. This may sound technical, but legally it is a major shift. For many years, statelessness was often treated indirectly, hidden inside asylum procedures, hidden inside migration files, or ignored completely. Now, under the new European framework, authorities will increasingly need to document nationality uncertainty, identify possible statelessness, and formally record these findings. This is important because invisibility itself has always been one of the biggest problems in statelessness cases. A person cannot defend rights that the system refuses even to recognize. But here is the danger. Europe is improving identification systems faster than solution systems, and this creates a serious structural risk. A person may now become officially recorded as stateless, of unclear nationality, or non-returnable, without actually receiving residence rights, nationality, travel documents, or legal stability. In other words, Europe risks creating a new category of people, identified but unresolved. And this is not merely an administrative problem, it is a legal problem, a human rights problem, and increasingly a constitutional problem. At the same time that Europe improves identification systems, many countries are also strengthening detention and return procedures. Germany recently implemented new pact-related reforms connecting asylum procedures directly with accelerated return systems. But statelessness cases do not function like ordinary migration cases. A stateless person often cannot simply be returned because no country accepts responsibility, nationality cannot be proven, or identity itself remains legally unresolved. This creates a dangerous contradiction. The state may classify someone as removable while having no realistic place to remove them to. And this raises profound legal questions. Can a person be detained for removal when removal itself may never realistically happen? How long can legal limbo continue before it becomes disproportionate? And how should courts react when administrative systems continue processing people without any realistic legal endpoint? The situation becomes even more complicated with current discussions about extra-territorial return hubs outside Europe. Several European states, including Germany and Greece, are supporting discussions around these external return systems. But statelessness exposes the limits of this model immediately, because if no state accepts the person, where exactly would that person go? And under what legal status? This is where migration policy collides directly with legal reality. A removal system cannot solve cases where legal nationality itself remains unresolved, and if Europe is not careful, it risks creating systems where people are processed administratively, detained procedurally, but never truly resolved legally. The deeper issue is not simply the absence of law. Europe already has human rights law, asylum law, migration law, nationality law, administrative law, and judicial oversight. The real problem is fragmentation. Different institutions operate inside separate legal compartments. One authority examines asylum, another examines nationality, another examines return procedures, another examines civil status. Each institution may technically follow its own rules correctly, while the overall system still fails the person completely. And this is exactly why statelessness cases often become structurally exceptional cases, because reality does not always fit neatly inside isolated procedural categories. The developments of 2026 are important. Europe is finally recognizing statelessness more openly. That is genuine progress, but recognition alone is not enough. If Europe builds stronger identification systems, Without equally strong resolution systems, then stateless persons may become more visible, more documented, more monitored, but not substantially more protected. And that is the real legal challenge now facing Europe, not simply how to record statelessness, but how to resolve it. Statelessness is not only a migration issue, it is not only an administrative issue. It is a test of whether modern legal systems are capable of dealing with exceptional human realities that do not fit neatly into traditional legal categories, and the answer to that question will shape the future credibility of European law itself.